Hello, I'm Urfan Khaliq, and I'm a professor of international law at Cardiff University. I was asked by my great friend, Professor Judy Priban, if I would rather do a video on my research during lockdown. So that's what I'm doing, and that's what I'll talk about for the next few minutes. Indeed, you can see I am in a lockdown state. I'm up here in a study in a loft conversion in my house, and it's around just after midnight, actually, on what is otherwise a very pleasant, or has been a very pleasant summer's day. Um, we, of course, all become academics because we love research, we love teaching, both are always equal passions of mine. In lockdown, teaching has taken on a somewhat different dynamic and dimension, and our research has become much more challenging. Carrying out our research has been much more challenging, at least for me. But still, in the small hours of the morning or the very late hours of the night, I have been beavering away as best as I possibly can. So I thought I'd talk to you briefly about the book I've been writing. Indeed, I'm delighted to say, and indeed I don't quite believe it when I say it, that the book I finished during lockdown. This is a book which has been co-authored with a great friend of mine, Professor Anver Emon, who's the professor of he's a professor of history and also Islamic legal theory at the University of Toronto. And this book has been many years in the writing. It's around 6 years, I would think, that we've been talking about this book and writing it, and it has evolved over a period of time. And the metaphor that one could use is of a journey, because not only have we been on many journeys, which are currently not possible in meeting and talking to people in the writing of this book, but it's also been one where our thinking has constantly evolved and developed, and we would think over time has become more sophisticated, but of course that's not for us to judge, that would be for others. I'll broadly explain what the book is about, because it has been difficult to finish because it has been simply so challenging. Anver and I were invited several years ago, 6 years ago or so, I suppose, by a number of governments to come and talk in various roundtables on a number of matters. We'd done some work in the past involving the International Bar Association and Princeton and the Salzburg Global Seminar. And we'd been looking at the relationship between broadly what one might call Islamic law and international human rights law. And we'd been involved in a project relating to that. And officials from some governments who'd been involved in parts of those projects invited us to come and talk to representatives from governments in The Hague, and then also over a period of time in a number of other different countries around the world, some in the Middle East, some in Southeast Asia, and also some in the Mediterranean region. The issue which was the thorny legal issue which was at stake was the problem of parental child abduction. This is where a relationship between two individuals who are not necessarily from this, who indeed are not from the same country, and the relationship breaks down, and one parent abducts the children and absconds to another. There is a successful, indeed one would say is the most successful, convention on private international. It's the Hague Convention of 1980 on parental child abduction, which addresses this. Now, that convention might be deemed as successful, and it might be deemed as operating very well between, for example, Great Britain and the United States, or Great Britain and Germany. But the membership of that convention is broadly what you might call between states who are European in their culture. So this would be North America, this would be European states, this would be Australasia, and so forth. Very, very few African states are parties to that convention. Very few states from what one might call the Middle East. There are one or two notable exceptions. Morocco, but Pakistan is in fact another one, as indeed somewhat alarmingly, and I don't say that lightly, is Iraq. So where children are abducted from, let's say, between Qatar and the United Kingdom, or between Pakistan and, let us say, Malaysia, for example, the 1980 Hague Convention doesn't apply. And what these governments were trying to talk to us about, and there were various roundtables and treaties were being discussed and negotiated, was how to extend the Hague Convention scheme. And we could see the sort of reluctance of states, and we could see that why this wouldn't work, but we could also see the assumptions being made on both sides. Now, Anver and I are obviously both BAME, we're visibly BAME, both of us. We both have what one would call names which have a Muslim cultural heritage. But we found ourselves unwittingly, or perhaps somebody had been so smart they had done it by design, we found ourselves becoming conduits between governments, in the sense that the Arab states, if I can broadly call them that, related to us as individuals from Muslim backgrounds, but also Anver is fluent in Arabic, which I'm not, and would speak Arabic and could translate Arabic and Quranic texts, in fact, more speedily and accurately than the legal translators and legal specialists who had come from some of the Arab countries. But equally, we related to and were related by the representatives from countries such as Canada, the United States, Australia, the United Kingdom, and so forth. And one set related to us because we spoke English, and we related to them because we were both educated in Western liberal academies. But the other side, if I can call them that, also related to us because they thought we understood them. What was fascinating in all of this was that we discovered that academics, or maybe not all academics, but certainly us, make very, very poor diplomats. Because we sat there and we'd critically analysed in our heads everything that was going on, and when a draft was presented and a set of proposals were presented, Anver and I looked at one another and said, broadly, and I paraphrase, there isn't a chance in hell this will be adopted, because this simply is incompatible with the legal systems of the states in question here. Well, it shows what we know because it was adopted without a murmur and was adopted by consensus. And that sort of made us think, what on earth is going on? And over a period of time, it dawned on us that terms were being used, assumptions were being made, and translations were being used as well. But what was being meant by the terms which were being correctly legally translated were entirely different. The assumptions were different, the bases were different. And in actual fact, these states were talking past one another. They weren't talking to one another. They were using the same terms, they were using the same language, but they didn't mean the same things. And they weren't actually confronting their mutual mistrust of one another because both viewed each other as mutually barbarians. And I use that term advisedly, I don't use that term pejoratively. I use it in the sense that it's always used, or has been historically used in international law, in the sense that we are the civilized, you are not the civilized, we don't necessarily recognize your systems. Now, the irony of much of this is that many of the states on what I'll broadly call the Muslim majority side were states which were the product of, or are the products of colonialism and the colonial encounter. And actually that colonial encounter had fundamentally framed how they view aspects of the law. Now, what we were dealing with were states, and these are states in the modern sort of in the concept of the modern state system under public international law. All of these were states. All of these were actors, indeed are actors. But and the states were using sort of the term, be it in Arabic, be it in English, of jurisdiction. That is the term that was being used. But jurisdiction meant entirely different things to them. Now, when international lawyers talk about jurisdiction, they're talking about the power of a state. The power of a state over its territory, the power of a state over its nationals, or the power of a state over its non-nationals, where they might be elsewhere. That's fine. But for Muslim majority states, they also assert jurisdiction over individuals who come within their territory due to their status, which is basically their religion. Now, the colonial encounter fundamentally altered the legal systems in many states, but family law, broadly speaking, or personal status law, was left preserved. Was left untouched, but was actually crystallized. It was mutated by the colonial encounter as well. So you have this wonderful paradox where you have states, Pakistan would be a good example, Egypt would be another, Malaysia would be another, there are many, many of them, where states seek to preserve their Muslim identity through the enactment of legal codes, which relate to personal status based upon Islamic precepts, or supposed Islamic precepts, but actually those Islamic precepts are the product of the colonial encounter. So to give you a very good example, in the Asian subcontinent, The family law codes relating to Muslims are the product of the colonial encounter with the British. Charles Hamilton's Adaya is still the sort of classic work which influences and continues to influence much of the family law codes in that part of the world. Well, we spent excuse me, we spent a lot of time talking to one another. A public international lawyer, a human rights lawyer, in myself, and an Islamic legal theorist and historian, and we knew that we couldn't write this book individually. We knew that we both had to get our heads together over time, talk in person in Toronto in the United Kingdom. I went to Canada a few times. Anver came to the UK, but we knew we had to talk together, keep talking, keep thinking. Our thinking evolved, and what we thought would be a shortish book, 50,000 words, 60,000 words, has become around 120, 125,000, I think it is. But it has been finished in the small hours. I finished proofreading it. We need to do an index. It's going to be called Jurisdictional Exceptionalisms. It's going to be published in the Law in Context series by Cambridge University Press, which we are both absolutely delighted about. And it has been a labour of love. It has been a journey, which is the metaphor. Writing the book took us on many journeys, emotional and also physical. But it is the end of the journey now. There are other journeys to be carried out to carry on this particular work. We hope to draft a model treaty going forward, because what we've explored is why the law cannot work, but how the law could work in some respects. But we need to write rather a model treaty for that. But that'll be for another journey, another leg of the project, and one which we will undertake when we are no longer in lockdown. I hope that was of interest, and I hope that was of some use. Bye-bye.